We're back on the record on docket 25-3448 FH People of the State of Michigan versus John Joseph Magola. Counsel, your appearances.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the State of Michigan.
Good morning, Your Honor. Amanda Tringle, appearing on behalf of Mr. John Magola, who is present to my left, along with Assistant Public Defender Rob Palmer.
Good morning. All right, are there any preliminary matters? I just met with Brian, the law clerk, and he had one change. I think there was a spelling error. I think he's made that. So based on that, then, are the impaneled jury instructions reviewed and appropriate on behalf of people?
Yes, Your Honor. I've had a chance to review them in full, the instructions after the impaneling of the jury, and the people after the corrections that were made this morning have no additional corrections.
Counsel?
That is correct, Your Honor.
All right, are you calling the jury or are there other preliminary matters?
No additional matters from the people, Your Honor.
None for the defense.
All right, my plan is to read these, go into openings, and then depending on where we are, take a brief break, and then I see your first witness is here, is that correct?
That is correct, Your Honor.
All right, no objection from the people having him here during openings, is that correct?
Correct.
Or I'm sorry, from defense?
That's correct.
All right, very good. The jurors, please.
All rise.
Good morning, thank you. You may be seated. Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. In a moment, I will ask you to stand and swear to perform your duty to try the case justly and reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Please stand and raise your right hand. Do each of you solemnly swear or affirm that in this action now pending before the court, you will justly decide the questions submitted to you? That unless you're discharged by the court from further deliberation, you will render a true verdict, and you will render your verdict only on the evidence introduced and in accordance with the instructions of the court. So help you God.
Yes.
Thank you. You may be seated. You have notepads there. During the trial, you may take a note. You will get notes. You may not share them until deliberation. In regard to what I'm reading now, you certainly can take notes, but you don't have to. You will each receive a copy of what I'm now reading. It's really important that you are able to hear what I'm saying as well as then look at the written document. So if you want to take notes, that's great. Just don't let the note taking interfere with your ability to listen to the instructions. As I've just said, you'll receive a written copy of the instructions I'm about to read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions that I will also read to you, and you'll have a copy in writing to refer to. And that you can use all of my instructions as a considered whole during deliberations. I will now explain some of the legal principles you will need to know and the procedure we will follow in this trial. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that defendant is innocent. This presumption continues throughout the trial and entitles defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove his innocence or to do anything at all. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The people are asserting that defendant committed the following count, and of course, as I said yesterday, defendant has pled not guilty. Count 1, weapons carrying concealed. Defendant is charged with the crime of carrying a concealed pistol. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, a pistol was in a vehicle that defendant was in. Second, defendant knew the pistol was there. Third, defendant took part in carrying or keeping the pistol in the vehicle. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. Defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. Defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, defendant's attorney may also offer evidence, but does not have to. By law, defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence I let in. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the only ones who will decide what the facts of this case are. Your responsibility is to decide what the facts of this case are, and in that way to decide the case. This is your job, no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case R is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or any part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There are no fixed set rules for judging whether you believe a witness. However, it may help you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. At times, you may hear me strike testimony. If something is struck or not allowed to be introduced, you may not consider that as evidence. The questions the lawyers ask the witnesses are also not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. Doesn't happen in every case, but in this particular case, you're allowed to ask questions. There should be in your notebooks, there's some blue or green paper. So what will happen is I will turn to you and ask if the jury has any questions. Please write legibly. If your handwriting is not so good, please print. You don't ask them directly. The process that I use is that you will write the questions. Brian, you'll raise your hand. Brian will collect those. Counsel will approach, and collectively we decide if the question should be asked or not. I'm the final decision maker. So if there's any blame about your question not being asked, it's on me, not counsel. I have to follow certain laws and rules. Additionally, when we can, sometimes we understand what you want, or we can only answer part of a question. So we might rephrase it or rewrite it so we get where we think you want to be in your question. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to Brian, who will give it to me. Do not show your questions to the other jurors. Similarly, do not show your notes to any other juror. It's kind of like taking a test right now. You just keep your eyes on your own paper, and then during deliberations, that's different. If your question is not asked, it's because I determined under the law the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately and we will take care of that. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions outside of your hearing or outside of your presence. And while you're in the jury room, I may have to take care of other matters that have absolutely nothing at all to do with this case. We do try to keep those to a minimum, but they do happen. This is a very short trial, so I don't know that they will happen in this trial, but if they do, pay no attention to the interruptions. Do not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I will send you to the jury room specifically for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all jurors are present. So there's 2 restrooms in there. If someone uses the restroom, although they're present in the jury room, they're not there at the table. So the discussion must cease until they again are seated at the table. You must not talk to defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has absolutely nothing at all to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop, explain that you're a juror and you are not allowed to discuss the case. If they continue, leave and report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply, and you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side or the other. So to be fair to both sides, you must follow this instruction. The restrictions I'm about to describe are meant to ensure that the parties on both sides receive a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside of the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor or prejudice one side or the other. These restrictions continue until you are discharged from jury service. And the way that I do this, there's a jury of 14 right now. We have 2 extras, and we have that because sometimes things happen. This is a short trial. I don't imagine we'll lose anyone, but I have had people suffer family emergencies, a heart attack or other things, food poisoning during jury. So we would release that person. Now, Siri's talking to me. I should hold him in contempt. But anyway, what will happen is 2 of you will be discharged only in my courtroom, and this is different. I don't remember if any of you have served before other judges, but the way that I do it is that 2 of you are discharged, but only to go about your business. You're not discharged from jury duty technically. We do this because someone, as I said, during deliberations might fall ill. And if that happens, then we would, by lottery, pick out which one, or maybe both of you, depending on something disastrous happening, to come back. And then the deliberations would start fresh. So what will happen is, for the 2 of you who are discharged, Brian will call you when there is a verdict and release you that way. And then if you want to know the verdict, and I think so far 100% of all people who've been discharged want to know the result. So we'll tell you the result and then you're free and you can talk about it with whomever you wish. It's your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You may not talk to AI and ask questions. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, magazines, or encyclopedias. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it would become necessary for you to visit or view the scene, court staff would take you there as a group under court supervision. You must not consider as evidence any personal knowledge you may have about the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other manner. If you discover a juror has violated my instructions, report it to court staff immediately. Again, you may take notes during the trial if you wish, but you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, and that would be when I instruct you that we are now at deliberations, you may then use your notes to help you remember what happened in the courtroom. If you do take notes, do not let anyone except the other jurors see them, and that's only during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. What we do is simply see if there what's on what has writing. We don't read it. Brian actually takes custody of them, and then he'll simply rip off the section until he gets to a clean section and put it through the shredder. I've had jurors who want to see their notes go through the shredder, and if that's you, Brian's happy to accommodate you. You can see, as I explained a moment ago, we've chosen a jury of 14. After you've heard all the evidence and my instructions, we will draw lots to decide which two of you will be dismissed to form a jury of 12, and I've explained the dismissal process in my courtroom. And that really, it saves a lot of county dollars, so we don't have to try the case again because we don't have the requisite number of jurors. Possible penalties should not influence your decision. If you find defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. I may give you more instructions during the trial, and after the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the law that applies to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my final instructions, you'll go to the jury room to decide your verdict. A verdict in a criminal case must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. So at the end of the trial, based on what the lawyers want, they may ask me to poll the jury. Polling the jury means that I will ask you individually if the verdict that the foreperson just read is the verdict yours personally, and was it the verdict of the whole jury? And you would each have to answer both those questions individually. It's important for you to keep an open mind and not make a decision about anything in this case until you go to the jury room to decide your verdict. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. On behalf of the people, are you satisfied with the reading of this set of instructions?
People are satisfied, Your Honor.
On behalf of the defendant?
Yes, Your Honor.
Thank you. On behalf of the people, are you ready for opening statement at this time?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court. Members of the jury, we have a Second Amendment right to bear arms. Everyone is aware of this. However, for the safety of the public, there are rules and regulations that must be followed, especially when it comes to firearms, and in particular, loaded pistols inside of vehicles. And unfortunately, you are going to hear today that the defendant, Mr. Magola, did not follow those rules. And we are here today because of an incident that occurred where the defendant, John Magola, decided to drive his vehicle with a loaded pistol without the legal right to do so on April 19th, 2024 in Lansing Township, Ingham County, state of Michigan. As a defendant, Mr. Magola has a right to a trial. And as a prosecuting attorney, it is my job to prove that the defendant committed the crime of carrying a concealed weapon beyond a reasonable doubt. Now, as I said during jury selection, each crime is made up of parts called elements. And these elements are what I need to prove to you all here today. Now, the judge has already read over those elements, but because these elements are so important to your job as jurors, I want to go over them one by one, so you know exactly what you're listening for and looking for when hearing the testimony and seeing the evidence here today. Now, the crime of carrying a concealed weapon has three elements. The first element is that a pistol was in a vehicle that the defendant was in. The second element is that the defendant knew that pistol was in the vehicle. And the third and final element is that the defendant took part in carrying or keeping the pistol in that vehicle. Now, in order for us to meet our burden and to prove this crime to you, we plan on calling Officer Gage Brownell with the Lansing Township Police Department. You are going to hear from him all about what happened on April 19th, 2025. You will hear from Officer Brownell about the reason for the stop. You will hear about the stop itself, and you will hear about when Officer Brownell asked the defendant for license and registration. He saw a pistol in Mr. Magola's glove box. You will hear that Mr. Magola admitted he did not have a CPL at the time. And you will also hear that when being arrested and being searched for his person, ammunition for the pistol was found on his person. Finally, you will be seeing pictures of the pistol as well that Officer Brownell took. As it is a dangerous weapon, we are not bringing the actual pistol here into trial. We will be showing you photos. Additionally, the plan is to also show you Officer Brownell's body camera of the stop and search of the vehicle itself, as well as from video of inside the vehicle that Mr. Magola was in after he was arrested. And you will be hearing some statements that he made to himself. After this evidence, members of the jury, it will be clear beyond a reasonable doubt that the defendant is guilty of carrying a concealed weapon. Thank you.
Opening at this time,
Yes, Your Honor.
you may proceed.
Good morning, ladies and gentlemen of the jury. First, I want to thank you very much for being here today. I know some of you were not thrilled at the prospect of being selected for a jury. Good news is, this will be a short trial. And you won't have to serve again for another year. Now, what I'm asking of you in return is what you all promised to do when we selected you. Because you were all chosen for a reason. You were chosen because Mr. Magola and I and the prosecutor believed that you would take your role very seriously. You were chosen because we believe that you will keep an open mind. You were chosen because we believe that you will not just take a cursory look at what's presented, but you will take a look with a critical eye. You will evaluate the things that you see. Now, you've been read their instructions, and I know Assistant Prosecutor Buxton just went over the elements with you. I'd encourage you, as you listen to the testimony, to pay very close attention to what piece of evidence you think could satisfy those elements. To make things a little bit easy on you, I'll go ahead and let you know. Element number 1, a pistol was found in the defendant's vehicle. We are not disputing that. What's in dispute are going to be elements number 2 and 3. How do you show what someone knew? How do you show intent? Those are some of the critical questions I want you to be asking yourselves whenever you hear the evidence that's presented. Now, most importantly, what I want you to remember is that the prosecutor has the burden of proof. At this point, if you were to go and testify or go and deliberate, you all promised and acknowledge your duty would be to find the defendant not guilty. Your position should not change. Your position should not change unless you are convinced beyond a reasonable doubt that every element has been met. It's not good enough to be convinced beyond a reasonable doubt that one of the elements were met or that 2 of the elements were met. All 3, beyond a reasonable doubt. Ladies and gentlemen, as you listen to the evidence, we ask that you keep an open mind. We ask that you not make a decision until you've heard everything. We ask that you remember your duty, your oath, to presume Mr. Magola's innocence, to hold the people to their burden of proof, When you go back to deliberate, you'll have questions. One of the important things to remember is unanswered questions are not the defendant's job to answer. If there are questions remaining that don't sit right with you, that's reasonable doubt. You all promised to ensure, or you promised that you would not hold it against Mr. Magula to test. You would not hold it against Mr. Magula if he chose not to testify. You would not hold it against him if he chose not to explain. Those are the things that we ask of you, and those are the reasons that you're chosen. Thank you.
First witness.
Yes, Your Honor, the people call Officer Gabe Brownell for the stand.
Good morning.
Good morning.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
Thank you. Put your hand down, you have a seat. Pull the chair as close to the microphone as you can, so you're comfortable. Feel free to adjust it. And when you are ready, please state and spell your name for the record.
Gage Brownell, GAGEBROWNEL.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Officer Brownell, how are you employed?
I'm a patrol officer at Lansing Township Police Department.
How long have you been a patrol officer with the Lansing Township Police Department?
I was sworn in May 9th of 2024.
What are your job responsibilities as a Lansing Township patrol officer?
As a patrol officer, my responsibilities include patrolling the areas of Lansing Township, responding to calls for service, and enforcing traffic violations.
When was the last time you were working?
Last night and this morning.
Thank you. Were you working on April 19th of 2025
I was.
in the same capacity as a road patrol officer?
Yes.
Did you make contact with a John Magola on that day?
I did.
At around what time?
It was approximately 1:37 in the morning.
What started this interaction with Mr. Magola?
I was sitting stationary on Lake Lansing.
I'm sorry, I didn't hear you. You were saying stationary?
Yes.
Sorry.
I was sitting stationary on Lake Lansing, near a business, 1384 Lake Lansing Road. I observed Mr. Magola pass me. His silver Honda Odyssey did not have a headlight, which is a civil infraction. I followed the vehicle and created a traffic stop with Mr. Magola.
Where was the stop conducted?
Once his vehicle came to a stop here on Lake Lansing near New York Avenue.
Is that in Lansing Township?
The stop stopped in the city of Lansing, which is not Lansing Township. The violation occurred in Lansing Township.
Understood. And that's in the county of Hingham, state of Michigan?
Yes.
And after you pulled over the vehicle, did you make contact with Mr. Magola?
I did.
Is that individual here in the courtroom right now?
Yes.
Could you please identify him by a piece of clothing that he's wearing?
He's wearing a red t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection?
No objection.
It shall so reflect. You may proceed.
Thank you, Your Honor. Was there anyone else inside of the vehicle at that time?
No.
What did you do when you first made contact with Mr. Magola?
I made contact with Mr. Magola. I advised him who I was, who I worked for, and the reason for the stop, which was his headlight. I requested his driver's license, registration, and a valid proof of insurance.
Were you dressed in the same uniform as you are right now?
Yes.
What did he do in response to your question?
He provided me his driver's license and proceeded to enter his glove box for the other paperwork that I requested.
Did you notice anything unusual when he opened his glove box?
Yes, I did.
What was that?
Inside his glove box, I observed a black object, which appeared to be leather. As Mr. Magola was attempting to locate his papers, he was holding his hand on top of a piece of paper, concealing that item.
What was your understanding of what that object was?
When I initially seen it, first thought I had was that is a weapon. I trained on that, I know what that is. It looks to be a holster and a firearm.
You stated training. What training have you received in regards to firearm identification?
I've been to a firearm identification class on how to manipulate firearms and identify them. I've also received basic training in my police academy.
And have you seen firearms in the course of your duty as a patrol officer?
Yes,
Did Mr. Magula appear to do anything when he'd opened the glove box?
it appeared to me that Mr. Magola was trying to conceal that item by putting his hand on top of a piece of paper, creating a barrier between my eyes and that weapon, but I was able to see it.
What did you do when you realized that this may be a firearm?
I asked Mr. Magola what was under that paper. I asked him to remove it, and then he did so.
At that point, were you able to confirm what that item was?
Yes,
What was it?
it was a black handgun in a holster.
What did you do after seeing this handgun?
Immediately, I told Mr. Magola to get out of the vehicle.
Did you ask Mr. Magola anything in relation to the handgun?
Yes, based off his reaction to my statement, which was in calm in nature, I asked him, do you have a CPL? So that might be a situation.
And what was his response?
He advised me he does not have a valid CPL.
What did you do at that point?
I reiterated him getting out of the vehicle, and I approached him.
And when you approached him, what did you do?
Placed Mr. Gula in a handcuffs to the rear of his back, double checked those handcuffs for tightness, and double locked them. At that point, Mr. Gula was under arrest.
After arresting him, did you conduct a search of this person?
I did.
Did you find anything of note during that search?
Yes, during my search incident to arrest on Mr. Magola, I located a small pouch on his belt. Inside that pouch was a loaded magazine for that same handgun in the glove box.
After searching Mr. Magola and finding this ammunition, what did you do at that point, Mr. Magola?
I placed him into the rear of my patrol vehicle.
After placing him in custody in your vehicle, what did you do next?
I had other units arrive on scene. I briefed them with the incident. And after that, I approached the vehicle and secured the weapon and deemed it safe.
I am approaching you as what has been marked as People's Proposed Exhibits 1 and 2. May I approach, Your Honor?
You may.
Officer Brownell, can you please tell the jury what I've just handed you?
Hand me a photo of the handgun inside the glove box before it was removed from the glove box. And then a separate photo of the handgun sitting on the seat.
That first photo you said, is that People's Proposed Exhibit 1?
It is.
And then the other photo, what is that People's Proposed Exhibit 2?
It is.
Are those photos that you took?
They are photos I took.
Are those photos fair and accurate representation of what you saw on that time?
Yes.
Your Honor, at this point, the people wish to admit People's Proposed Exhibits 1 and 2 into evidence.
Any objection or voir dire?
No, Your Honor.
Admitted.
Thank you, Your Honor. May I publish to the jury via Elmo?
You may.
I am putting on the screen People's Proposed Exhibit 1. I apologize for the glare. Could you please explain to the jury what you see in this photo?
Yes, I see a handgun. The red on that handgun is the front sight that's pointing towards
The
the,
one on the handgun?
the red
On the-
color on the front of the handgun. That is the front sight of the handgun. That is pointing towards the passenger door where I was standing at the time of the traffic stop.
So zoom in a little more. Is that the red part you're talking about at the end of the pistol?
Yes, it is.
And you said that was facing where in the vehicle?
It was facing the passenger door, which is where I approached the vehicle. Therefore, the muzzle was facing towards me.
Thank you. And then I have put in people's proposed exhibit, or people's exhibit 2. Can you please explain to the jury what this is?
After I took the gun out of the glove box, I set on the scene, took another photo to get an overall photo of the gun itself.
Thank you. When taking this gun into custody, what did you do with it?
Once I deemed that I had other officers on scene with Mr. Gola, I took the handgun, I unloaded it and cleared the chamber, locked it back and verified that that chamber was cleared. And then I secured that and the 2 magazines in my front seat of my patrol vehicle.
You said you unloaded the vehicle. What does that mean? Does that mean that the pistol was fully loaded?
Yes, when I unloaded the pistol, there was a magazine inserted in the magazine well. I took that out and then I racked the slide to eject. There was 1 round in the chamber.
Was the lock on,
The lock.
and the weapon, the safety?
The safety, I don't believe there was a safety on this that I recall.
Was there any other ammunition in the vehicle?
Not in the vehicle that I can recall.
Thank you.
And you would say that you had found ammunition on Mr. Magola at the time of your search. Did that ammunition match up with the ammunition found inside of the vehicle or inside of the pistol?
Yes,
Did you continue your investigation after this?
I did.
And what did you do?
I returned my patrol vehicle. I ran the pistol serial number through our Ingham County Union Dispatch, and they verified that that pistol is registered to Mr. Magola. I also ran Mr. Magola to verify he did not have a valid CPL, which he did not.
Could you please explain to the jury what the lien system is?
Yes, so the lien systems are law enforcement information network. That is a computer database which is composed of any information that might help me do my job on a daily basis. As far as your driving status, in this case, CPL status, it also might tell me about warrants or anything along those lines that might help me in my daily duties.
Have you been trained to use the lien system?
I have,
And do you use the lien system on a regular basis in your role as a patrol officer?
yes.
And then I just want to confirm, you had stated that through the lien, the firearm had belonged to the defendant?
Yes,
And you said you had searched his status of the CPL. What did you find when you searched that?
I found that he was not permitted to conceal carry a pistol.
Did you have a body cam at the time of this incident?
I did,
Is that typical in your role as a patrol officer?
yes,
And was your body cam playing on that day?
yes.
What starts the playing of that body cam footage?
It can either be me activating it manually or my overhead emergency lights in the vehicle.
If I were to pull up that video, would you be able to recognize it?
Yes,
I am pulling up what has been marked as People's Proposed Exhibit 3. If we could switch to the puck. Thank you. I believe it's on your screen right in front of you as well.
yes,
Is there a date up in the corner of this video?
there is.
And what is that date?
April 19th, 2025.
And is there a time as well?
Yes,
What is that time?
1:37 in the morning.
Would that have been the date and time of this stop?
Yes,
I know this is just the first screen of this proposed exhibit, but does this appear to be your body cam footage?
yes,
Does this appear to be a fair and accurate representation of what you saw on that day?
Yes,
And you've reviewed this video prior to today?
I did.
At this point in time, Your Honor, the people wish to admit People's Proposed Exhibit 3 into evidence.
Any objection or voir dire?
This is the body cam footage.
This is the body cam footage, yes, the first 8 minutes of that body cam footage.
No objection.
And you've had an opportunity to review that.
Yes, Your Honor.
Admitted.
Thank you. I'm going to play this video.
Officer going on Lansing Township Police Department, reason I'm pulling you over is your headlight being on. Yeah. Alright, I need your driver's license registration for your insurance. Okay. How's your night going? Yeah, where are you at? Oh, okay, how's that going? That's good. Ross, what's under that paper? What's that? Step out. You have a CPL? Step out. Or I'll take it. Turn around. Turn around. Hands right back. Interlace your fingers. Interlace your fingers. Interlace them like you're praying. Interlace like you're praying. Put your hands away from the back. Alright, let's go back to the car. Alright. So you don't have a CPL? Not current. Okay, okay. You have anything on you, so stab me, stick me, poke me, blow up on you? Any more weapons on you? Pocket knife. Okay, I don't care about that, so. Right now, what's going on is, at the moment, you're under arrest, okay? Can't be driving around with a loaded handgun in the car. Okay. CW. Okay. I'm gonna check your status for CPL. If I find out you do have a CPL, it's not. Okay. Okay. You can have your car and sneak with your. You, with your glove box, you have it down there and covered with paper, that tells me straight up, you sometimes have that gun. Right. So, alright. Just to reiterate, nothing on you crazy? No. I know it's a pocket. From what's in there? Is this that gun in the low box? Yep. That's what I'm charging. Is this come off, is it on the belt? Yep.
Gonna pause real quick at 3:03. You just pulled something out of this pouch on the defendant. What did you just pull out?
Pulled out a loaded magazine that went to the handgun that was in the glove box of the vehicle.
Thank you. I'll be continuing playing now.
Mind if I just, you love to take it off? I don't want to pull anything off. Is that okay? I'll do the belt back on. Back. Alright. Is this your Carlos? You seem pretty calm to the situation. Have you dealt with this before? No. Okay. I appreciate you being a calm person. Ourselves. Yeah. Anything in your hand pockets? You have tight shoulders? Okay, all right, get a second unit here, I'll take you to how long you're going to use this. Okay. Sound good? You'll be going down the jail time, okay? Having gone in your car like that, it's CCW, that's a problem. Is it? It is. I'm gonna double lock the car, so I'm gonna sit down back, so you'll have. Is there any other weapons in the car before I go through it? Okay.
Pause for a minute at 5 minutes and 58 seconds. Is this another officer?
This is Sergeant Taylor with the Lansing County Police Department.
Okay, what was his involvement in this investigation?
He assisted with calling for a tow for the vehicle,
Okay, nothing additional?
not that I can recall.
Okay, thank you. I'm gonna be playing the video again.
For CCW, over the small box, it's seen something that I have to cover with this paper. Photograph it, clear it, secure it. We'll get a tow started. Not Mirandized him yet, but I did tell him he's under arrest for 3 ounces. He said he had a seat on the past, but it's not renewed and he needs to get renewed, so. Contact hole. Yeah, for firearm coverage.
After you took that pistol into custody,
I didn't hear you.
after that, you took the pistol into custody?
I did.
Does your vehicle record video from inside of the vehicle?
Yes, my dash cam records the outside front of my vehicle, and there's a backseat camera as well.
What activates that back camera?
The backseat camera is activated manually.
Do you know if your backseat camera was on after Mr. Magola was taken into your vehicle?
I turned it on, yes.
I were to pull up that video, would you be able to recognize it?
I would.
I am pulling up what is marked as people's proposed exhibit 4. I just pulled up on the screen what is it marked as people's proposed exhibit 4. Is that the same date that was on the previous video?
Yes,
And I know this is a still, but does this appear to be a copy of the video footage from the back of your patrol vehicle?
yes,
And does this appear to be a fair and accurate representation of that video?
yes.
At this point in time, the people wish to admit people's proposed exhibit 4 to evidence.
Any objection or what, dear?
Yes, Your Honor. Briefly on voir dire.
You may.
Officer, were you in the vehicle at this point?
I don't recall if I was in or outside the vehicle, this exact moment.
Okay. Were you in the vehicle the entire time that the defendant was in the vehicle?
No.
There was a period of time that he was in the vehicle and you were not there?
Yes,
If I told you that was roughly the first 3 minutes and 56 seconds, would you have any reason to disagree with that?
No.
Okay, because you would have been searching the vehicle, or
Correct.
I apologize, searching the defendant's vehicle.
correct.
Okay, so you were not there to observe what occurred in that vehicle at that time.
No, I was not.
So you can't, you don't have any personal knowledge about what occurred in the vehicle that first 3 minutes and 56 seconds approximately.
Outside of the recording here,
Okay, so you would not be able to say whether or not what there is captured on the recording is a fair and accurate depiction of what actually occurred.
I reviewed this portion of this recording before our case here today.
Okay, but you don't know if the recording is a fair and accurate depiction of what occurred in the vehicle while you were not there.
Correct.
Because you don't have firsthand knowledge of that.
Correct.
We would object to omission of the first 3 minutes and 56 seconds of this video based on improper foundation, his lack of personal knowledge to be able to verify that what occurs in that first 3 minutes and 56 seconds is a fair and accurate representation of what occurred.
Further voir dire?
Yes, Your Honor. Mr. Brownell, did you edit that video in any way, shape, or form?
No,
So this video would have accurately depicted what had occurred despite the fact that you were not present.
correct.
Was there anyone else in the area that outside of your site could have tampered with that?
No one else was in my vehicle.
And no one else was around the perimeter that you were working in?
Sergeant Taylor was on scene, but he did not enter my vehicle.
Okay, so he was within your eyesight. You would you have known if he entered your vehicle or dealt with that video in any way?
Yes, I would have known.
And let's talk about chain of custody. What has happened since that time when that was taken? Do you know where this video was?
It was uploaded to our evidence.com in the case for this case here today.
And have you reviewed it since to make sure that it is in the same order as when it was taken in your vehicle?
Prior to today, I reviewed the case in evidence.com and everything appeared to be in order.
It's admitted.
Thank you, Your Honor.
Your objection's preserved.
I'm going to play the video.
Should have kept it in my waistband. I thought that it might have it out.
Thank you. Afterward, did you end up taking Mr. Magola to the Ingham County Jail?
I did.
Thank you. Nothing additional, Your Honor.
Cross.
Morning, officers.
Morning.
Ryan.
Is it?
It's on the clock. Press the little button.
Now, your to draw your attention to April 19th, 2025. You indicated that you observed the defendant's vehicle pass with a missing headlight.
Correct.
And
Your Honor, for a second, point of order, if we could turn off the video until defense is ready to play their video.
thank you.
Thank you.
And does your cruiser have video recording?
There is video recording.
Okay. And the video recording of your cruiser, how does that video activate?
That video activates either manually or with my overhead emergency lights. And has a 30-second playback feature.
Okay. So when you initiated a stop, that would have, on Mr. Magola's vehicle, that would have captured that?
Yes.
If I show you, defense proposed exhibit A, which just the first frame. Would you be able to tell me if you recognize it?
Yes.
Do you recognize this image?
I do.
What's the date of that image?
The date on this image is April 19th of 2025,
What's the timestamp?
1:36 a.m.
And does that appear to be a fair and accurate depiction of what the view you had from your cruiser that evening?
Yes.
Defense moves to publish, to enter into evidence, defense proposed exhibit A.
People have no objection, Your Honor.
A is admitted.
Now, looking at this image, this still image before we play, do you see defendant's vehicle?
Yes.
Okay. And can you describe it?
It is a silver Honda Odyssey, which is a silver van.
If I circle, is this what you're referencing?
Yes, that is what I'm referencing.
You can circle it on the screen, officer.
Now, the way these motor vehicle cams, video cams typically operate is they start recording 30 minutes back from when you activate your lights, correct?
30 seconds.
30, thank you. 30 seconds before you activate your lights, correct?
Correct.
Okay, so we should expect to see your lights activate around the 30-second mark. I'm gonna stop it right at the 30-second mark. Do you see your lights activate?
Yes.
Okay. And that's, at that point is when defendant would have noticed your lights activate as well, correct?
Correct.
Okay. So, when you observed defendant's vehicle pass, you noticed that he had a missing headlight.
Correct.
Okay. And you promptly initiated that traffic stop.
Correct.
And I believe you mentioned that that would have been for a civil infraction.
Correct.
Okay. And can you explain for the people who may not know what a civil infraction is?
Yes. So a civil infraction would be the level at which point that this vehicle has a motor vehicle violation. Civil infractions are your standard tickets that you get on the road outside of criminal charges.
Thank you. And I'm gonna play the next approximately 8 seconds. Stopping at 38 seconds. You see the defendant's vehicle stop at that point?
Correct.
Okay. And it's fair to say that you maintained a visual on the defendant's vehicle from the time you activated the lights to the time the vehicle stopped?
Correct.
Okay. And during that 8 second, excuse me, that 8-second clip we just saw, you'd agree that the defendant pulls over immediately on seeing your lights?
Yes.
At no point did you witness his vehicle swerve?
No.
You didn't witness any other bad driving?
No.
Now, you mentioned that this is a Honda Odyssey.
Yes.
Do you remember what year that was?
I don't recall.
If I told you it was a 2004, do you have any reason to disagree?
No.
So that's a vehicle that's over 20 years old.
Correct.
And again, the headlight wasn't just burnt out, it was missing entirely.
That is correct.
Okay. So you'd agree that the vehicle was more of a fixer-upper than like something fancy or flashy?
I wouldn't say it's a fancy car.
I wouldn't say it's a fancy car, no.
And it's a minivan, right?
Yes,
Okay. Is there a trunk?
there's a hatch,
But no trunk?
not that I'm aware of. Legally, it's in New York, Edward X-ray date 8536, on the silver Honda.
And do you see the, excuse me, do you see the individual in the photo?
Point of order, Your Honor, just to clarify the time for the purposes of the record.
Thank you. It stopped at 1 minute and 12 seconds.
Thank you.
Do you see the individual in the video approach the vehicle?
Yes,
And that's you?
that is,
Okay. And you'd agree that you just approached the vehicle about 1 minute and 11, 1 minute and 12 seconds?
I agree.
Okay. So from the time you started the stop, or you activated your lights at 30 seconds into this video, to the time you arrived at the passenger's door, it's only about 30 seconds roughly, or 40 seconds roughly.
Correct.
Now, when you approached Mr. Magula, you advised him you were stopping him for a missing headlight,
Correct.
and he was calm.
Yes.
When you asked him for his driver's license, registration, proof of insurance,
Correct.
and he cooperated.
Correct.
I'm gonna pull that video up as well. Just- I'm showing you defense exhibit, proposed exhibit B. Do you recognize this?
I do.
How do you recognize this?
This is my body worn camera.
Okay, and it's from April 19th, 2025.
Correct.
Same incident we've been talking about this morning.
Correct.
Okay. Does it appear to be a fair and accurate depiction of your body camera from that evening?
Yes.
Defense moves to admit defense proposed exhibit B.
Any objection or wonder?
No, Your Honor, I will say it looks as if it's the same as people's supposed exhibit 3. I guess there's this additional 45 seconds.
Thank you, admitted.
Thank you. Stopping the video at 20 seconds, that's when you approach the vehicle.
Yes.
You knock on the window,
Yes.
passenger side,
Yes.
and you have your flashlight on.
Yes.
No, boss, Officer Barnell, Lansing Township Police Department. The reason I'm pulling you over is your headlight being on. Yep. Alright, I need your driver's license, registration, and insurance. How's your night going? Yeah, where are you working at? Oh, okay, how's that going? That's good.
Stopping the video at 43 seconds. So at this point, you asked for his driver's license, registration, proof of insurance, and he promptly handed you his driver's license.
Correct.
You were asking him some questions, he answered.
Correct.
He advised you just coming from work.
Yes.
He was still calm.
Yes.
Right. And Now, you mentioned that you've been an officer since May of 2024,
Correct.
and you had some training before that.
Yes.
And now in your training experience, I'm sure you learned to watch for certain behavioral cues.
Yes.
And those behavioral cues, you watch for those behavioral cues because they could be indicators of potential criminal activity.
Yes.
And some of those behavioral clues include like attempts to flee police, nervousness,
Correct.
fidgeting,
Correct.
restlessness,
Correct.
stuttering,
Yes.
avoiding eye contact,
Yes.
rapid breathing.
Yes.
Right. And you're essentially taught to look for those behavioral cues because you can articulate, or so that you can articulate and explain why you had a reasonable suspicion that a crime occurred.
Correct.
And the rationale behind that training is that a person's thinking kind of dictates their behavior.
Yes.
Now, before we go any further on the video, I want to talk about your interaction with the defendant up until this point. Mr. McGould pulled over immediately.
He did.
He didn't attempt to flee.
He did not.
He was calm.
He was.
He wasn't fidgety or restless.
Not that I recall.
He answered your questions clearly.
Yes.
He wasn't stuttering.
No.
He was making eye contact with you.
I don't recall.
Okay. Breathing normally.
Yes.
Okay. Cooperative, handing you his driver's license, answering your questions.
Yes.
Okay. So in fact, before Mr. Magola opened the glove box, you did not have any suspicion or reason to believe that a crime had occurred.
Not at that time.
Not at that time. Thank you. So at that point, since you didn't have any reasonable suspicion that a crime had occurred, you would not have had the lawful authority to order him to open that glove box.
Correct.
And you didn't order him.
No, I did not.
And you didn't pretend to have the lawful authority.
I did not.
In fact, Mr. Magola willingly opened the glove box.
Correct.
Now we paused the video for a few minutes now, but we're still at the 43-second mark. And you arrived at the vehicle at 20-second mark, correct? You've only been there for approximately 23 seconds at this point.
Approximately, yes.
Okay. Stopping the video, actually it should have been about 45 seconds. That's when Mr. Magola opens the glove box willfully.
Correct.
Okay. Starting again at 44 seconds. I'm gonna stop this at 50 seconds. Try to stop this at 50 seconds and go back a second for 2 seconds. Stopping this at the video at 50 seconds, just for a moment. So on your direct exam, you testified that when the defendant opened the glove box, you said that he was holding his hand on top to sort of conceal the weapon.
Yes.
Okay. Now, do you recall why Mr. Magola opened the glove box?
I believe Mr. Magola was searching for his registration and
Your Honor, speculation. I don't believe that Mr. Brownell would know exactly why the glove compartment was opened by Mr. Magola.
Well, in fact, you later learned that he opened the glove box to give you his registration.
Correct.
I'm going to allow it overruled.
Now, you prepared a report, correct?
I did.
And do you recall whether or not you described Mr. Magola using his hand to conceal the weapon in your report?
I don't recall the word.
You don't recall the report, I'm sorry?
I recall the report. I don't recall the wording on this.
Okay. If you had an opportunity to review your report, would that refresh your recollection?
Yes, it was.
Showing people a copy of the report, permission to approach the witness.
Granted.
Handing you a copy, you're welcome, handing you a copy of your report. I want you to take a minute to look over that. Look up whenever you've had an opportunity to review it.
I reviewed the report.
To retrieve. Thank you. Now, after you've reviewed your report, do you recall indicating in your report that Mr. Magola ever concealed the weapon with his hand?
In my report, it states he covered it with papers.
Covered it with papers, okay. But you had asked him to retrieve his registration and proof of insurance.
Correct.
And that's when he opened his glove box.
Correct.
So he was moving papers in the glove box while trying to locate his proof of registration and insurance.
It would require him to move papers.
Okay. But after reviewing your report, you can confirm that he did not attempt to conceal the gun with his hand.
It does not say that in my report.
Okay. Starting the video from 52 seconds.
Is your headlight being on? Yeah. All right, I need your driver's license, registration, proof of insurance.
Just for clarification of the record, my timestamp had not updated correctly. It looks like it started approximately 30 seconds in. So we'll just play it from here.
How's your night going? Yeah, we're in it, man. Oh, okay, how's that going? That's good. Boss, what's under that paper? What's that? Step out. You have a CPL? Step out.
Stopping the video at 59 seconds. Just prior to that, you asked Mr. Magola to move the paper,
Correct.
and he did.
Correct.
And that's when you could get a really clear view that it was in fact a gun. You asked him if he had a CPL.
I did.
And he informed you that it was not current.
Correct.
You ordered him out of the vehicle.
I did.
Now, on direct testimony, you indicated that you at some point confirmed Mr. Magola's CPL status in lien.
I did.
And you were able to confirm that the statement that Mr. Magola told you that his CPL was not current was true.
That is correct.
Starting the video at 59 seconds.
Right. Interlace fingers. Interlace your fingers. Interlace them like you're praying. Interlace like you're praying. Hands away from that. All right. Don't have a CPL? Not current. Okay, okay. You have anything on this stand mistake with both the law, everywhere?
Pausing, and then pause about 150. Approximately 155. Again, you ask him if he has a CPL and he says not current.
Correct.
Again, that is a true statement. Now, as part of your investigation, after placing Mr. Magola in the back of your vehicle, you retrieved the gun.
Correct.
And you got that from the glove box.
I did.
And when you retrieved the gun, it was contained inside a leather holster.
That is correct.
Do you know what kind of holster that is?
It appeared to be in the waistband holster.
And you photographed it.
I did.
You cleared the round in the chamber
I did that as well.
and you unloaded it.
Correct.
I'm going to skip ahead to that portion of the video. Starting the video at approximately 6 minutes and 46 seconds. I apologize, 6 minutes and 43 seconds. Pause it right here at 7 minutes and 39 seconds. At this point, you have cleared 1 round from the chamber, correct?
Correct.
Could you hear what you said there?
Can you replay it for me, please?
Yeah, I'll see if I can turn it up too. You go back about 10 seconds, starting again at 7:43. And for the record, that video was played approximately at 7 minutes and 45 seconds to 7 minutes and 47 seconds. Did you hear it that time?
I did hear it.
And what was it that you said?
So this is an 8-round magazine, or I said mag in the video. So there's 1 in the chamber. There's 7 currently in the magazine. So that makes 1 more going in.
Okay,
One more.
1 more going into the magazine, yes.
okay. So if there was 1 in the chamber and 7 rounds in the magazine, and it was an 8-round magazine, that means all the bullets that were at once in that magazine were accounted for.
Correct.
No missing bullets.
Oh.
Now, that evidence was, or, I'm sorry, that gun was seized and taken into evidence
Correct.
for use at a potential trial. Correct?
Correct.
And was it ever tested for prints
It was not dusted.
or swab? Was it ever swabbed for touch DNA?
No.
Sorry, just one moment. Returning to your body worn camera video. Trying to locate 343. Turning back to your body worn camera video at minute marker 3 minutes and 31 seconds.
Carlos? Be pretty calm for the situation, you know, this before. No. I appreciate you being a calm person.
Stopping at 3:55. Would you fair to, it's based on, is it fair to say that Mr. Magola remained calm throughout your entire interactions?
Yes,
Respectful
there,
and cooperative?
yes,
At any point, was he threatening,
no,
aggressive? And he was truthful.
he was.
Now, I want to go back a second to the law information, to LEAN, the Law Enforcement Information Network. You mentioned on direct that LEAN gives you information that helps you do your job.
That's correct.
And it can tell you individuals' driving status.
Yes,
It can also tell you if the vehicle is registered, correct?
that's correct.
And it can tell you if the vehicle has a proof of insurance.
Again,
Returning to your video. Sorry. Returning to your body on camera video at 5:57, or yeah, 5:59 actually. Actually, jump back to
CCW, of this little box, I see something black.
5:59. And this is when the sergeant arrives on scene,
yes,
and he didn't do much but call for a tow, you indicated. But you did give him an accurate description of what occurred that night.
correct.
And that night was obviously had just occurred. So what was fresh in your memory at that time is probably more accurate than today.
Yes,
Did you hear that statement?
I did not over the cars.
I'll go back.
From CCW, of this little box, I see something black, the cover of
Stopping the video at 6:07. Did you hear it that time?
Yes, I did.
And what did you hear?
Heard he opened the glove box and seen something black, he covered it with a piece of paper.
Okay. Thank you. Now. Taking a pretty thorough review of your interaction that evening,
Yes,
okay? And is it fair to say that during the course of that evening, you did not see defendant ever outside the vehicle with a gun?
yes, fair to say.
You did not see the defendant ever enter the vehicle with a gun?
Yes, that's fair to say.
You did not see when the gun got in the vehicle
I did not see.
or how the gun got in the vehicle?
Correct.
You didn't ever see Mr. Magola in physical possession of a gun?
Outside of it, inside of this vehicle, no.
You never saw it in his hand?
Not physically inside of his hand, no.
Okay. And you didn't see the gun get placed in the glove box?
No, I did not.
You didn't see who placed the gun in the glove box?
I did not.
Or when the gun got placed in the glove box?
Correct.
So you don't know why it was in the glove box?
No, I'm not aware of why it was in the glove box.
Or how long the gun had been in the glove box?
Correct.
You don't know whether the defendant knew he was carrying a gun when he entered his vehicle?
I did not. Can you restate your question?
You do not know whether the defendant knew he was carrying a gun when he entered his vehicle?
I do not know that.
And you don't know whether the defendant intended to carry his gun when he entered the vehicle?
I do not know that either.
And you do not know if the defendant knew the gun was in the glove box when he opened the glove box?
Based off the observations I had and the statements I made today, I believe that he was aware as soon as he opened his glove box. Outside of what would be indicated in my report, that he was just moving papers on top of it.
And so given your vantage point, the fact that you were out standing outside the passenger side window, shining your flashlight,
Correct.
and given that the defendant was seated in the driver's seat and having to reach across to the glove box, it's fair to say that you might have even realized a gun was in his vehicle before he knew a gun was in the vehicle.
That's speculation. I would object.
Response?
Your Honor, just the last line of questioning, the officer did indicate that he believed, based on his personal observations and what he did noted in his report, that he thought that the defendant realized the gun was in the glove box once he opened the glove box.
But that's not your question. You asked. To it.
My understanding, Your Honor, the question was essentially.
I got it. It says you might have even realized a gun was in his vehicle before you knew a gun was in the vehicle. I'm not going to allow that. Rephrase. What he might have done is irrelevant to me.
When Mr. Magola opened the glove box, he did so voluntarily.
Correct.
Thank you, officer. No further questions.
Redirect.
Brief redirect, Your Honor. Officer Brownell, on cross, the defendant's demeanor was mentioned a lot. Was there any point in time that Mr. Magola seemed shocked or surprised at all to you?
Yes, when I advised Mr. Magola that it was a felony, he seemed surprised at that.
Thank you. On direct, it was also mentioned that this talk about the papers. So I just wanted to confirm with you, was the action you saw Mr. Magola doing moving papers, or was it something else?
Based on what I can recollect and my body camera footage and what's in my report, I remember Mr. Magola seeing into his glove box, placing his hands on top of papers, and he was pushing a paper down against that firearm that was in the glove box.
So he was holding that piece of paper with his hand.
Yes.
Defense also had mentioned dusting or swabbing the gun for prints. Why did you not do that?
If I'm hurt in this case, that gun is registered to Mr. Magola.
Thank you. Nothing additional, Your Honor.
May this witness be released from subpoena?
I don't know if the jury has any questions.
Oh, I'm
Your
so
Honor.
sorry. Does the jury have any questions? I forgot. Not every jury gets to ask questions. Does the jury have any questions? Seeing no hands raised, may this witness be released from,
Yes, Your Honor, this witness may be excused.
on behalf of defendant. Thank you very much for your time and testimony. You are now released from subpoena. Please do not talk about your testimony with any witness during the pendency of this matter.
Yes,
Thank
Your
you,
Honor.
sir.
Thank you.
Next witness.
At this point in time, the people rest, Your Honor.
All right, it's time for a break. Thank you, and hopefully your lunch is delivered.
All rise.
Thank you. You may be seated. Is there a motion at this time on behalf of the people? Or I'm sorry, on behalf of the defendant?
Yes, Your Honor, thank you.
You may proceed when you're ready.
At this time, the defense would make a motion for a directed verdict. We would submit to the court that not all the evidence, there has not been evidence to prove every element beyond a reasonable doubt. Specifically, whether there's been evidence to show that the defendant knew the pistol was there at the time he opened the glove box. We heard testimony that the traffic stop itself would have been a civil infraction. there was some discussion by the officer that the defendant may have attempted to cover the gun with a piece of paper. However, when you consider what happened prior to that, the fact that the defendant willfully opened the glove box, I think that raises a real question about whether or not he knew his pistol was in there. It is possible that the defendant did not, at some point, had placed the gun in the glove box and did not recall that the gun was there. We don't know when the gun was placed there, where the gun or where the vehicle was located when it was placed there. Had the defendant's car been located at his home, for instance, and his car parked on private property, it would have been lawful for him to open his glove box and put his gun in the glove box, and it would not have been a CCW. I think that under the testimony that we've heard today, there is a real question about whether or not the defendant had any knowledge that the pistol was contained in the glove box. It makes sense that it's almost irrational to think that he did, right? He's being stopped for a civil infraction. Very low level civil infraction, no potential criminal penalty. The defendant there was no reason that the defendant would have been required to open the glove box. The officer admitted that. He admitted that he did not have the lawful authority to order him to do that, nor did he pretend to have the lawful authority to do that. That was a willful action on behalf of the defendant. I think the willful action to open the glove box and reveal a pistol is the best piece of evidence we have to state of mind that he did not know that the vehicle or that the pistol was contained in the glove box. Otherwise, why would he open the glove box where it is concealed out of the view of the officer, only to try to cover it with a piece of paper? If it was something that the defendant knew was there and was trying to keep from the officer, he simply would not have opened the glove box, and he would not have been able to be compelled to do so. Alternatively,
Please turn your phone off, sir. Continue, counsel.
thank you, Your Honor. Alternatively, for purposes of an appellate record, the defense would like to raise a Second Amendment or an argument as it relates to the Second and 14th Amendment and the Michigan Constitution. As the court is well aware, the Second Amendment and the 14th Amendment grant an individual a constitutional right to bear arms. We assert that as applied to this defendant, that the charge of carrying a concealed weapon under MCL 750-227 violates Mr. Magola's constitutional right to bear arms. Now, obviously, the court's aware of the U.S. Supreme Court decision in Bruin, as well as the Michigan Court of Appeals, the Michigan Court of Appeals decision in Langston. And what's interesting to note is while Bruin and Langston both mention that the Michigan carried concealed weapon statute being a shall issue, with it being a shall issue statute, is not unconstitutional on its face. However, both Bruin and Langston note that just because it's not unconstitutional on its face does not mean that that it could not be unconstitutional as applied. What's interesting is the court in Bruin and cited by Langston specifically address the issue of whether the issue of whether a shall issue state is immune from as applied challenges, and they conclude that it's certainly not. It is absolutely possible that any licensing scheme can be done or conducted in such a manner that could be a constitutional violation. Here, we submit to the court that it is a violation of, it's not necessarily the licensing requirement in general. There are certain things that the courts have held are permissible constitutional requirements to carry a concealed license. Those things include background checks. Those things include verification that the person's not been mentally or doesn't have a mental health issue, makes them a danger to themselves or others. What's specifically interesting to note is that the court does not, and actually expressly states that, this is in looking at a footnote 9 in the Bruin decision. The court expressly references an element of Michigan's CPL requirements that is potentially ripe for a challenge, and that is, they say that at the end of the footnote, it says that that said, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimens where, for example, lengthy wait times in processing licensing applications, or, and this is where it's important, exorbitant fees deny ordinary citizens their right to public carry. Now, the entire basis of the Second Amendment is for people to have the right to carry for purposes of self-defense. I understand there is a lawful way Michigan citizens can transport a firearm in a vehicle absent a CPL. However, the manner in which you're lawfully required to carry that, broken down, separate from the ammunition, practically speaking, would prohibit anybody from actually being able to use that firearm for self-defense should an emergency situation arise. The act of having to go to the trunk or the compartment or the lockbox where it's not accessible to them to reassemble the gun, no bad guy ever is going to hold on a second while I go and get the gun and put it back together. So the alternative to be able to carry without a CPL in an automobile is not sufficient to ensure the core of the Second Amendment, which is to bear arms for purposes of self-defense. Now, we have a defendant who previously had a CPL. We heard testimony, his CPL was expired. There's nothing on the record to indicate that he would be ineligible to obtain or renew his CPL. The fact of the matter is, exorbitant fees, it costs $115 to renew. And the defendant, the only thing that changed between the time he applied for his first CPL and the time that his CPL expired was the fact, or was his financial situation. At that point, he did not have the financial ability to pay the $115 application and registration fee. Constitutional rights cost hundreds of thousands of service people already, so that they can be afforded to every American, not just the Americans who have $115 to be able to pay to assert that right. The only thing that would have prohibited, at the time of the stop on April 19th, 2025, Mr. Magola was not on probation. He was not on bond conditions. He had not been convicted of any misdemeanor or felony charge that would bar him from being able to obtain his CPL. He had not been under any court order for mandatory evaluation, mandatory mental health treatment. He was a US citizen. He was a resident of the state of Michigan, having resided here for almost 30 years, a registered voter. He was over the age of 21. Having had a CPL previously, he'd had knowledge and training and safety handling of firearms. To renew, you don't even have to take a class. You can self-educate. There are resources available. That's something that he did regularly. Mr. Magola is a Second Amendment advocate. He reads more than the 3 hours required. Probably, I don't want to overestimate, but I would guess tenfold beyond what is required for those licensing requirements. Again, he had not had a conviction of any enumerated misdemeanor charge. He was never dishonorably discharged from
any enumerated what?
I'm sorry, a misdemeanor charge that would make him ineligible for a CPL. Never dishonorably discharged from the US Army, never been found guilty but mentally ill of any crime, or subject to any order of involuntary commitment, or diagnosed with a mental health illness that made him, or that it concluded he was a danger to himself or others. Not under a court order of legal incapacity in this state or anywhere else.
Capacity?
Legal incapacity in this state or anywhere else. And he had a valid issued driver's license. We heard evidence of that can infer some of Mr. Magola's financial struggles. He's driving around in a 20-plus-year-old car with a missing headlight. People who have the money to be able to afford to fix their headlights do. The mere fact that Mr. Magola qualifies for the public defender's office is evidence that he is indigent. We'd ask the court to take judicial notice of his lack of prior criminal convictions, his residency, and the other factors. The only thing Mr. Magola was not able to satisfy was the fee. Bruin states, page 62, the constitutional right to bear arms for public self-defense is not a second-class right, subject to an entirely different body of rules and other Bill of Rights that other Bill of Rights guarantee. Cited McDonald at 561 US 780. We know of no other constitutional right that an individual may exercise only after demonstrating government officers some special need. That's not how the First Amendment works when it comes to unpopular speech or the exercise of or the free exercise of religion. That's not how the Sixth Amendment works when it comes to the right to confront a witness against him. That's not how the Second Amendment works.
You're going too fast.
I'm sorry.
That's not how the Sixth Amendment works when?
When it comes to a defendant's right to confront witnesses against him. And that's not how the Second Amendment works when it comes to public carry for self-defense. I'm proposing to the court that while this is specific to the Bruin opinion, no one has to pay money to receive their First Amendment right. No one has to pay money for their Sixth Amendment right. Indigent defendants don't have to pay to have their right to counsel. Indigent defendants who cannot afford to pay the $115 fee that's required by the state to obtain a CPL should not be denied their right to self-defense, or their right to bear arms for purposes of self-defense in public, in a vehicle. The CPL statute, or this, having a valid CPL is a defense to the CCW statute. When people are indigent and cannot afford to pay that fine, they're denied that ability. And as I mentioned before, the alternative of lawful transport is not sufficient to allow someone to carry for purposes of Second Amendment argument, or I'm sorry, purposes, the real purpose of the Second Amendment, which is to bear arms for purposes of self-defense. Therefore, we would respectfully request that the court declare Michigan's concealed pistol license requirement unconstitutional as applied to Mr. Magola. Dismiss all charges predicated solely on the absence of the CPL, which would include his charge of carrying a concealed weapon if he stands before the court today. Thank you, Your Honor.
Thank you. Response?
Thank you, Your Honor. I'll take those one at a time. First, in regards to the directed verdict, under the Hampton case law, it states that the trial judge must consider the evidence presented by the prosecution up to the time the motion is made and view that evidence in the light most favorable to the prosecution and determine whether a rational trier of fact could have found that the essential elements of the crime were proven beyond a reasonable doubt. Your Honor, as I have said, and as you have said, there are three different elements for this charge. The first, that a pistol was in a vehicle that the defendant was in. As you heard during opening, the defense has already stated that that is the case. And you heard from Officer Brownell that this pistol was found in the vehicle. This pistol was found not only in the vehicle, but fully loaded. Second, that the defendant knew that the pistol was there. Your Honor, we have basically everything except for the defendant's explicitly stating that he knew the pistol was there. The pistol was inside his vehicle. He is the only person that was inside that vehicle on that day. As you heard from Officer Brownell, this pistol is licensed to the defendant. Not only that, Your Honor, but during the search of the defendant's person, we found ammunition that matches that pistol on his person, which is circumstantial evidence to show that he knew that that pistol was inside the vehicle. Why else would he have ammunition on his person for that pistol? Finally, Your Honor, well, additionally, he made motions to cover this pistol with paperwork inside of the glove compartment. He also, Your Honor, didn't, and I understand that the defense was also using this, the fact that the defendant was calm, but the only time that the defendant even seemed shocked or surprised at all during this stop is when the officer mentioned that this was a felony charge. Finally, Your Honor, I want to direct your attention to People's Exhibit 4, the video of the defendant inside the back of the patrol vehicle, where he makes two statements. That first statement being, Your Honor, let me get the exact quote for you.
You don't need to, I recall.
No, okay.
But
So,
if you want to make your record, you may.
He did not think the officer was going to be on that side of the vehicle, and that he should have kept it on his waistband. Those statements show that he had knowledge of the gun, knew the gun was in the glove compartment, and should have kept it on his waistband instead, Your Honor. And then third, the element being that the defendant took part in carrying or keeping the pistol in the vehicle. It's clear, Your Honor, the The vehicle was his, the pistol was his. He made statements saying he should have kept it on his waistband, implying that he knew it was inside of the glove compartment. It's clear he took part in carrying and keeping the pistol. I think a rational jury would find the essential elements, even if not looking in the light most favorable to the prosecution, quite frankly, Your Honor. So I believe that you should deny the motion for directed verdict. In regards to the additional arguments in regards to the CPL statute being unconstitutional under the Second Amendment, the defense itself mentions People v. Langston, a case by the Court of Appeals, which I agree is not, it is not a, I apologize, Your Honor, it is not a case that is a case from 2024 by the Court of Appeals that states that the statutory requirement that a person must possess a valid concealed pistol license in order to carry a pistol in an automobile does not violate the Second Amendment. This case comes after the 2022 case, New York State Rifle and Pistol Association, Inc. versus Bruin, which the defense mentioned at length. And I want to talk about this very briefly, this case note here, this footnote at the bottom that states that exorbitant fees should not stop someone from having a Second Amendment right. Your Honor, it's $115. I just had a chance to look up the price for a violation for defective equipment, which is the reason the stop even occurred. At base, Your Honor, it's $111, and that's before the courts put on whatever additional fees they put on, which is substantially similar to what the CPL license renewal is. He was going to have to pay that amount anyways with defective equipment. I would not say a civil infraction traffic violation is an exorbitant fee, Your Honor. So I believe that argument is unfounded. So I would also ask that you not grant the motion in regards to the CPL requirement being against the Second Amendment. Thank you.
Final word, if any.
Thank you, Your Honor. Just to incorporate Michigan Constitution, Article 1, Section 6, every person has a right to keep and bear arms for the defense of himself and the state. Every person, not every person with $115 they can spare. And turning to Langston itself denotes a footnote actually, Langston itself cites footnote 9 of the Bruin's court's majority opinion. That same footnote that I read to the court that indicates, that being said, a permitting scheme can be put towards abusive ends. And continues to state, giving the example at the end that says, or exorbitant fees that deny citizens their right to public carry. On that same page, footnote 11 of Langston indicates, echoing the Supreme Court's footnote 9, we emphasize that we are not determining whether Michigan's scheme does or does not violate the Second Amendment, Second and 14th Amendments, either in its terms or in its application. When the court issued their opinion in Langston, they said, we are not going to find shall issue state, or the requirement for a CPL and shall issue states to be a blanket unconstitutional violation of the Second Amendment. That does not mean, and they expressly state, that does not mean that the terms or in application can't result in a constitutional violation for a particular defendant. Amendment 2 and 14 of the US Constitution and Amendment 1 and 6 of the Michigan Constitution applies to everyone, regardless of financial status. And constitutional rights should not only be available to people who can afford to pay for them.
Thank you. The evidence on this record, I have to look at this in the light most favorable to the non-moving party, which is the people. And the question is, can the jury determine, based on the elements and the evidence provided by both counsel on each side of this case, can they, do they have enough information to decide? I'm not going to stand in the place of the jury because they do have enough to decide. Count 1 has already been conceded. Count 2 and 3 is up for their interpretation. Now, as to the constitutional analysis here, I'm not going to find that this statute is, or the Constitution are at loggerheads. The statute of Michigan, the CPL, is equally applied and there's a rational basis for it. If you can afford a gun, then you need to afford all of the costs that go with it and accept all the rights and responsibilities therewith. And I understand financial hardship. I think the issue was really perhaps he couldn't even afford the cost of a headlight. I don't know his financial situation. Certainly this has cost him more than he probably ever anticipated, but that's really not the issue here. I understand what you're saying is that everyone should really be able to carry a weapon without paying the government any additional monies. But sadly, there is a reason for these additional monies. Now, restoration of driver's license for those that drive without a license, the state did some exorbitant fees that I think were found, or ultimately one of the governors forgave them all because they were so exorbitant. It precluded people from having a license. They were like $5,000. $115, I don't think is exorbitant. In fact, I suspect when the legislature rules on these things, passes laws, discusses them, they're always talking about, with every law, are they revenue positive, revenue neutral, or revenue negative? I suspect with the red flag laws and with everything else that goes on with guns that it's revenue negative, but I have not researched it. But nonetheless, having a cost, when it does cost for a weapon, if you can afford a weapon, you have to afford all the fees that go with it, and keeping those updated. The fact of the matter is, he has a gun. He was not denied purchasing a gun. But carrying concealed means he leaves it at home until he can afford the money. You return pop bottles, you do whatever, and you comply with the law. So I do believe in the Second Amendment. I was in the military for 20 years. I carried a weapon. I get it. But there are rationally based rules in regard to gun ownership, and people are dying at the hands of people who have illegal guns. And there's countless reasons this should be upheld and is constitutional as it's applied. It's equally applied to everyone. I don't think it violates, I'm not seeing that it violates the Second Amendment. Now, when guns are free, but we charge to have them, yeah, we're violating. But that's not the case here. And I'm not convinced at all by your arguments, although they're interesting. And maybe at some point I'll research them further, and maybe at some point they'll be found unconstitutional. But as long as we have so many illegal guns, irresponsible gun owners, and this is a way to validate, and he does, I have to say, this is the mildest case the people have ever brought before this court, and I wish there was a different resolution. We have time better spent than on someone who's law-abiding, who simply makes a mistake or could not afford the fee. But that's not my call. If the jury wants to make that call and nullify the elements, that's fine with me. The Second Amendment stands. But I am not finding that the statute is unconstitutional. There are too many reasons to find it constitutional from where I sit in this moment, in this space, in this time. So your motion is denied, and I'm finding that the statute is constitutional and compliant with the Constitution for various reasons. I could go into it longer, but we're into the lunch hour and I'd like to get moving on this case. So it's denied. Do you have any witnesses, or are we going into closing?
Your Honor, I would like to have an opportunity to confer with my client to discuss the evidence that's been presented before he makes that determination.
Let me know before we go on the record then with the jury present. We will simply go on the record and voir dire him regardless of whether his choice is to testify or to remain silent. Anything further?
What time should we return, Your Honor?
How about 1 o'clock?
Thank you.
Thank you, Your Honor.
You know, it's your run down here.
That?
No.
Oh, just.
No, we're just meeting. You're-
Okay. Okay, so I know you're good. Yep, sure.
Meetings on Friday. I think Friday we have to pull the jury from downstairs.
Okay.
Because
Yeah,
we're 3
it
week,
was very.
for a 3 week trial, I don't, so we're gonna.
Yeah, if they come up like, I don't know, in a line and speak at the microphone, but before it was very hard to hear because his office was.
Yeah, we'll work on that.
In the back. Do you need to eat or something? In the back?
I'm good.
All right. In the back.
Right, yeah.
Yeah, sure. Hey, Judge.
Yeah.
Would you be willing to sign the stip in order for Natalie and I?
Yes, I would. perception of whether or not defendant will testify. So we're back on the record. On behalf of defendant, is your client going to testify or not, or do you have any other witnesses?
Your Honor, I have consulted with Mr. Magola. I have explained to him his right to testify or to remain silent, and that must be his choice and his choice alone. After consulting with him and talking about his options and his evaluation of the evidence that's been presented, he has made the determination independently to not testify in this matter.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. You understand by choosing to not testify, you're giving up the right to testify, correct?
Yes.
And you've made this decision of your own free will.
Yes, I did.
Did anyone force, threaten, or coerce you to make this decision?
No, I did not.
Did anyone promise you anything that caused you to make this decision?
Did not.
Have you taken any medication, used any alcohol, marijuana, or other substance yesterday or today?
No, I'm not.
Any medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you've been satisfied with the representation of counsel?
Yes.
All right, so up until the jury actually enters and are told you're not going to testify, or there's not, the defense rests, you can change your mind, but once counsel says defense rests, you cannot change your mind because then the evidence is closed. Do you understand?
Understood.
Okay. Did you need any more time with your attorney?
No.
Did you have sufficient time with your counsel?
Yes, I did.
All right. And you've had a couple of attorneys and you've been working with both of them? Is that a yes?
Yes.
And you're satisfied with the whole team?
Yes.
Great. Any additional questions counsel would like to ask? So what we'll do is you'll rest, or do you have any other witness?
Other witnesses will rest.
And then you will go into closings, and I have the jury instructions, and they're all set since we don't need to add, or we do need to add the one, but.
I'll print them and then I'll bring them in while they're doing closing
Okay,
arguments.
so we're going to add that defendant not testifying, and sir, you understand that that can't be used against you in any way?
Yes.
Okay, very good. And there's an instruction as to that, which I will read to the jury. I'm sure your counsel has told you that, but just so we have that understanding. Okay, very good. All right,
I just want to confirm with the instructions, because looking over the ones that were submitted, there has been some jury instructions that we may not need to add, that we would need to take out.
okay, so do you want to look, Brian, did you pull
I-
them out?
I've taken most of them out that I think that don't need to be in, but I mean, I'm gonna bring them out as soon
Okay.
as I get the
So-
jurors, I'm gonna go back in, hit print, and then come back out with them.
Okay, so why don't we do this? Why don't we do closings and then we'll take a pause? And then you all can look at the jury instructions and then see if anything needs to be added back or if it's sufficient. Is that
Understood.
all right? Or we can go over it now, it doesn't matter to me.
Like stipulations and interviewing police witnesses, I've taken all those out because none of that came up.
And that would be fine, Your Honor. I fine either way, as if we want to either do it right now or wait until after closing, so I'm fine either way.
Well, he still has to add the one, so I'd like to give you a complete packet.
Okay, so then we can wait until after closing.
Okay, great, thank you. The jurors, please. Having fun?
All the fun. We're putting him to work on, he's running a prelim for me on Thursday morning.
Oh, great, fun.
It'll be
Good
fun.
case? Is it good case or just a?
No, it's okay. All rise.
Oh, good.
There's some things hard, for sure.
Good, good. Should we all zoom in? Thank you. You may be seated. On behalf of defendant, any witnesses at this time?
No, Your Honor. Defense rest.
On behalf of the people, are you ready for closing argument?
Yes, Your Honor.
You may proceed when you're ready.
Thank you. May it please the court. Members of the jury, as I stated during my opening, there is a Second Amendment right to bear arms. However, as I stated, for the safety of the public, there are rules that have to be followed, regulations that need to be followed, especially when it comes to loaded pistols inside of firearms. And members of the jury, you have heard the evidence, you have seen the videos. And the evidence is clear, members of the jury. Mr. Magula has been given his right to trial. And during this trial, you saw People's Exhibit 1 that shows the pistol inside of the defendant's glove box. And People's Exhibit 2, that pistol that was seen inside that glove box. You saw the entire stop and investigation done by Officer Brownell, who took the stand and testified to that stop and investigation as well. And then you even heard statements from the defendant himself in People's Exhibit 4. It is clear that the defendant is guilty of carrying a concealed weapon on April 19, 2025 on Lake Lansing Road in the county of Ingham, state of Michigan. As I stated, you heard from Officer Brownell and you got to see the investigation and stop for yourself. This was a simple traffic stop for defective equipment that turned dangerous when the officer saw a pistol in the glove compartment with the muzzle pointed toward him on the passenger side. You heard from the defendant. He did not have a CPL at the time of this incident. And that is why we are here, members of the jury. We are here because Mr. Magula was charged with carrying a concealed weapon. And as a prosecutor, it is my job to prove each of the elements to you all beyond a reasonable doubt.
It is my job to what?
To prove this to you all beyond a reasonable doubt. Now, the judge has given you instructions, and I have talked about the elements of those crimes as well. But once again, because of how important these elements are to your jobs as jurors, I want to go over each of those elements to show that we did prove each and every element beyond a reasonable doubt with the testimony of Officer Brownell and the exhibits that we brought before you all today. So, as I had stated, carrying a concealed weapon has 3 elements. The first element is that a pistol was in a vehicle that the defendant was in. Members of the jury, you heard during defense's opening that this is not in contention. People's Exhibits 1, People's Exhibits 2 show the pistol that was found in Mr. Brownell's or Mr. Magula's vehicle. This is clear. You heard from Officer Brownell. You got to actually see the video of him unloading the pistol. It is clear there was a pistol inside the defendant's vehicle. We have proven this element beyond a reasonable doubt. The second element is that the defendant knew that the pistol was there. And members of the jury, once again, this is clear. We have everything except for the defendant himself admitting that the pistol was in the vehicle. You heard from Officer Brownell that he ran that pistol and that pistol was registered to the defendant. Who else would put a pistol that belonged to the defendant inside of the defendant's own vehicle? A vehicle that he was operating solely that night, members of the jury. And not only that, you heard from Officer Brownell that after he ultimately arrested Mr. Magula for carrying a concealed weapon, he searched his person. And on a pouch on his belt, he found ammunition for that pistol. Why else would someone be carrying around ammunition for a pistol if they didn't know that there was that pistol available to them, members of the jury? That's not all. You heard from Officer Brownell that when Mr. Magula opened that glove compartment, he was covering that pistol with paper and hand. This action shows that he had knowledge of that gun and was trying to hide it and conceal it from the officer, members of the jury. And finally, members of the jury, you don't just have to take my word for it. I want to play for you all again, People's Exhibit 4. The video of Mr. Magula in the back of the patrol vehicle. Please listen closely. Pausing at 58 seconds. What Mr. Magula just said, I didn't think he'd come up on that side. What does that mean, members of the jury? Let's think back to People's Exhibit 3, the actual stop of Mr. Magula. You heard and you saw that Officer Brownell came up on the vehicle, not on the driver's side, but actually on the passenger side, the side of the vehicle where that glove compartment was, meaning that the officer would have had a better view of the glove compartment coming in from that side of the vehicle. That is what Mr. Magula meant when talking about that, showing he had knowledge of the firearm on that day. But let's listen more, members of the jury, because Mr. Magula says something else.
Should've kept it in my waistband, I thought that he might never get out.
I should have kept it on my waistband. The same waistband that the defendant had ammunition for the pistol. The same waistband that he would have been able to put the gun on thanks to the holster that that gun was on. Members of the jury, it is clear that the defendant knew of the firearm inside the vehicle on that day. We have proven this element. The third and final element is that the defendant took part in carrying or keeping the pistol. Members of the jury, all we need to use is common sense here. We've already proven there was a firearm in the vehicle, and we have already proven that the defendant knew about that firearm. And as you heard from Officer Brownell, and as you saw on the body cam, People's Exhibit 3, the defendant was the only person inside of that vehicle. The defendant was the only one that could have taken part in carrying and keeping that pistol, which belonged to him, inside of the vehicle. It was his car, it was his gun. He knew the gun was in the vehicle. Based off of all of the evidence that has come before you, based off of the defendant's own statements in People's Exhibit 4, we have proven this element. That's it, members of the jury. The 3 elements to create the peanut butter and jelly sandwich that is carrying a concealed weapon. These are the elements, nothing more, nothing less. Feel free to review your notes, discuss the testimony, take back the pictures and video back to your deliberations if you need to rewatch them again. And after all of that, you will have no other choice but to find the defendant guilty of carrying a concealed weapon. Thank you.
On behalf of the defendant,
Yes, Your Honor, thank you. Ladies and gentlemen of the jury, thank you for your time. Thank you for your attention. I hope by now you realize how important of a matter we sit before the court on. While it's a short trial, it's still a very important trial. At issue here is someone's Second Amendment rights. Second Amendment right to bear arms for the purpose of self-defense. Now, the people would have you, or have suggested that for purposes of public safety, it's very important that we regulate conduct. Yes. You've seen the evidence. Is there anything that suggests Mr. Magola is a threat to public safety? The way he interacted with police, remaining calm throughout the entirety? Nothing about Mr. Magola's actions suggests he's a danger. In fact, we heard at some point, Mr. Magola did in fact have a concealed pistol license. It had expired. That's why we're here. An expired license. Not because Mr. Magola is a danger to the community and shouldn't be able to possess a firearm, but because his paperwork was expired. You heard a lot of evidence. And I want to remind you of the burden of proof because it is incredibly important. The people have the burden to prove every element beyond a reasonable doubt. What does that mean? Beyond a reasonable doubt is to be without any fair or honest doubt to any of the possible element, or to any of the elements of the crime. With what you've witnessed today, I don't believe that to be possible. Now, the prosecutor suggests that statements made by the defendant, of which we have no context, is enough to prove elements 2 and elements 3, suggesting that it shows he knew the firearm was in the vehicle. I want you to consider something. Timing. Timing. The timing of knowledge. When Mr. Magola made that statement, he knew the firearm was in the vehicle. He just opened a glove box and saw it. That statement is not made until after opening the glove box and seeing it. Now, during voir dire, I asked everyone if you've ever forgotten something very important. Everybody answered yes. And we all agreed that at the time you were forgetting, did you know you were forgetting? No. You remember, maybe, once you've been reminded, seeing the gun in the glove box reminded him. The statements made in the video are without context. I should have kept it on my hip, something to that effect. Okay, but we don't know what he's talking about. Always? Never put it in the glove box? Timing is important. Timing is important because he had to have known, Mr. Magola had to have known that he was carrying the pistol into the vehicle at the time he entered the vehicle. There's nothing to suggest at the time he entered the vehicle, he knew he had his firearm on him. There's nothing to suggest that the defendant knew the pistol was in the glove box before he opened it up for the officer and saw it. In fact, I think the evidence suggests the opposite. He stopped for a headlight, a civil infraction. Someone who just needed to renew their CPL, their expired CPL. Is it reasonable to presume or infer knowledge when you have a defendant knowingly opening a glove box when he was not ordered to do so, but willingly and knowingly opening a glove box if he knew the gun was in the glove box at that time? That is not reasonable. The argument, the people put forth the argument that the officer testified that the defendant opened the glove box and attempted to cover it or conceal it with a paper in his hand. Well, if you recall, the officer initially testified he tried to conceal it with his hand. And I asked him, is that what you reported? He refreshed his memory and realized, no, actually, it was just paper that was covering it. And then we played the video.
Is that what he reported to the sergeant when he was summarizing what occurred? No, just that paper had covered it. And perhaps from the law enforcement officer's perspective, he interpreted the fact that the paper covered the firearm at some point as an attempt to conceal. But is that reasonable? Think about why the defendant went in there. Why the defendant willingly went into the glove box to retrieve paper, to retrieve his registration, to retrieve his proof of insurance. Of course, he's going to be looking through paper, shuffling paper. Consider the perspectives of the different individuals. Defendant seated in the driver's seat, reaching over with a flashlight from the opposite direction coming in. That doesn't necessarily help him see things better. In fact, that can impair his ability to see. The officer's perspective, who's closer to the glove box, shining in a light. But again, is it reasonable to think the shuffling of papers was for the purpose of concealing a gun? Or is it more reasonable to think the shuffling of papers was to locate the proof of insurance and the registration? Because if the defendant wanted to conceal the gun from the officer, he did not have to open the glove box. That argument put forth by the people is illogical. Someone who knows a firearm is contained in a glove box and chooses to open it anyway, just to cover it with paper. That's your reasonable doubt. Because that scenario is not reasonable. Let's talk about what was reasonable. Mr. Magola's interaction with the officer. Incredibly respectful. Mr. Magola's truthfulness with the officer. The officer asked him, "Do you have a valid CPL?" And he said, "Not current." He did not try to conceal the fact that he didn't have a CPL. I point to that fact because it goes to his credibility and his trustworthiness. And his state of mind, frankly. When I talked to the officer, or when I questioned the officer, I talked about behavioral clues. And there was a very precise reason that I did that. Because the entire premise, as the officer testified, the entire rationale behind that training to look for behavioral clues is that a person's subconscious can come out in their actions. That a person's thinking dictates their actions. I make that point again to circle back. If I know a gun is in the box, in the glove box, why would I open it to attempt to conceal it with paper? It's not rational. The behavioral clues do not suggest knowledge. They suggest the opposite. They suggest a lack of knowledge. Not just the mere opening of the glove box. The other behavioral clues I asked the officer about: attempts to flee. No, he pulled right over. Nervousness. No. Wasn't fidgeting, wasn't restless. He was answering his questions. Wasn't stuttering, he was speaking clearly. Again, those are subconscious behavioral clues that can give very valuable evidence to an individual's state of mind. And that did provide very valuable evidence to Mr. Magola's state of mind. The lack of any criminal intent. He did not intend, there's no evidence that he ever intended to carry the firearm into the vehicle. Without the intent to carry a firearm in the vehicle, you cannot find that the third element, the defendant took part in carrying or keeping the pistol in the vehicle, is met. And its intent is a imperative portion of that element. The defendant knew. Again, the behavioral action, or the actions that occurred, the defendant's behavior, do not suggest he knew. If he knew he was pulled over with a firearm, and he'd be nervous, right? He's nervous, he's worried, and he's certainly not going to open the glove box. Not unless he's forced to. That didn't happen. There are huge actions speak louder than words, particularly when you do not have context to what those words mean. The prosecutor has indicated that he's given you all the pieces of your peanut butter and jelly sandwich that you need. You got bread. I'll give you that. I gave you that in opening. We're not denying that a gun was found in the defendant's glove box. However, the charge is carrying a concealed weapon, not being near a gun, not owning a car, not driving alone. The people have the burden to prove beyond a reasonable doubt that my client was not just in the vehicle with the gun, but that he knew the pistol was there. And that he took part in carrying it, meaning he intended to do so. When you go back there and you start taking a look at all the evidence, I don't want you to look at a piece of bread and call it a peanut butter and jelly sandwich. I want you to take it apart. I want you to take an inquisitive look. Peel apart the pieces of bread. Look at the evidence. Look to see if there's any sign of knowledge. Given the behaviors and the actions demonstrated by the defendant. Look to see if there's anything that suggests he intended to carry. Where's the peanut butter and jelly? If the people fail to prove any one of those elements beyond a reasonable doubt, then the law requires that you find him not guilty. You know, you heard the prosecutor emphasize that he was a driver, he was a sole occupant. But being a driver, being a sole occupant does not necessarily prove you have knowledge of all the contents in the vehicle. The law does not require, nor does it permit that a finding of guilt merely on the fact of your sole occupancy of the vehicle. More must be shown. There were a series of questions that I asked an officer about the unknowns in this case. Timing is important. Intent to carry had to have taken place at the time he entered. Knowledge had to have taken place at the time he entered. He had to have known he was in possession of the firearm before the firearm was discovered. The officer testified that it appeared to him the defendant learned the gun was in the box once he opened it. I think that makes sense. Actions speak louder than words. The law prohibits finding someone guilty based on assumptions. Assumptions are not evidence. When you go back to deliberate and you're unsure, people have proved that the defendant knew beyond a reasonable doubt that the defendant knew that the gun was in the glove box. People fail to prove that element beyond a reasonable doubt. You must return a not guilty verdict. If they fail to prove he intended to carry the gun into the vehicle, you must return a not guilty verdict. Momentarily, you guys will be given instructions on the law. Then we'll remind you of burden of proof of defendant's presumption of innocence. It'll list the elements of the crime for you, so you can reference them while making your decision. At some point, and remember, you all during voir dire recognized accuracy is more important. An accurate verdict is more important than a quick verdict. But ultimately, a verdict will result. And you'll get to leave. Your jury service will be done for a year. You'll be driving home. Now, there'll be a couple scenarios here. if you are driving home and you hear, and you think to yourself, did I make the right decision? Ladies and gentlemen, given the people have the burden of proof, my client has the presumption of innocence. If you're asking yourself that question, you only made the right decision if you voted not guilty. Because that question is a signal to you. It's your subconscious. Did I make the right decision? Reminding you that there was a reasonable doubt. If you're driving home and you vote guilty and you have that thought, unfortunately, but mostly for Mr. Magola, that means you probably did not make the right decision. Because again, that thought is your subconscious reflection of reasonable doubt. Reasonable. Is it reasonable to open a glove box willingly if you know a firearm is in there? Is it reasonable to interpret those actions of looking for a proof of insurance and a registration? Is it reasonable to interpret the moving of papers as an attempt to conceal a gun? Once that person just willingly opened the glove box? It's not. That is your reasonable doubt. Reasonable doubt can also be formed on not just the evidence, but the lack of evidence. No one saw Mr. Magola with the gun on his person. No one saw the gun enter the car. No one saw how the gun got into the glove box. What we don't know can also be reasonable doubt. I think when you go back to the deliberation room and you take into account all the evidence and lack thereof that has been presented, the only just and fair verdict you can return is not guilty. Thank you.
Final word on behalf of the people.
Thank you, Your Honor. Members of the jury, defense came up here and said actions speak louder than words. Let's talk about the actions of the defendant. The defense wants to come up here and say that the defendant was just shuffling around papers. But I want you to remember Officer Brownell's testimony on redirect, because I clarified with him what happened. Was this just a shuffling of papers? And he said no. The defendant took a piece of paper and pushed it against the gun. That is the defendant concealing the weapon, showing that he knew about it and showing that he intended to have it there. The members of the jury, the defense wants to come up here and basically say that because the defendant acted calm and acted respectable to the officer and followed the officer's instructions, that he didn't know about the pistol and that the laws just shouldn't apply to him. It's not how it works, members of the jury. The laws apply to everyone. And the defendant is not allowed to keep a gun if he does not have a CPL. The defense also wants to talk about the statements that I had mentioned and said that there's no context to them. The context, members of the jury, is People's Exhibit 3. The entire stop that you got to see with your own eyes of the officer walking to the passenger side of the vehicle, not the driver's side, as typically would happen during a traffic stop. And it's not like the defendant said something along the lines of, I forgot that gun was in there, or how did that gun even get in there? No, what he said was, I should have kept it on my waistband. Members of the jury, what else could that possibly mean? Based off of everything that happened, based off of the ammunition for that pistol that was found on his waistband. What is reasonable, members of the jury? The defense wants to say this is all assumptions, but members of the jury, this is all circumstantial evidence. Circumstantial evidence that the defendant knew the gun was there and that he took part in carrying and keeping it. Circumstantial evidence, the fact that he himself owned the gun, the fact that he himself owned that vehicle, the fact that he was the only person in that vehicle, the fact that he had ammunition on his person, the fact that he had ammunition that belonged to that gun on his person, the fact that he tried to cover up the gun with paperwork inside of his car, and the fact that he made these statements, said, I didn't think he would go on that side, and I should have kept it on my waistband. Members of the jury, all of this together becomes clear that the defendant knew the gun was inside the vehicle and took part in carrying that, in keeping that pistol inside of the vehicle. This is beyond a reasonable doubt, not possible doubt. Reasonable doubt, members of the jury. If it was just one or two things, sure. But all of this evidence together, it becomes simple, members of the jury. The defendant knew about the gun. Under the defendant's interpretation of what is reasonable for knowledge, the defendant himself would have had to admit that he knew the gun was there. The officer would have had to have been following him before he even got out of his car, before he even got into his car. That's not reasonable, members of the jury. We have to take the facts and circumstances into consideration. There is context behind these words. There is context behind everything that happened. And you have that context, members of the jury. Find the defendant guilty of carrying a concealed weapon. Thank you.
We're gonna give you about a 5-minute break, and then we will proceed with closing and then deliberations. We are back on the record, council. You had an opportunity to review the proposed jury instructions and iron out any difficulties. Is there anything that you need me to rule on or you need to make a record of?
No, Your Honor, I believe we're in agreement on the instructions at this point. The only two that we had added were 4.1, the defendant's statements as evidence against the defendant, and 4.16, intent. But I believe the rest of the jury instructions are sufficient, and those two have been added at this point.
And behalf of the people?
That is correct.
All right, thank you. Then, I'm sorry, Mr. Ring, I have the corrected version.
You do, Judge.
Thank you, the jurors, please.
Right.
Okay, that is
Yeah. Apparently you are with me. Let me just say this. All rise.
Thank you. You may be seated. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. As I said earlier, you will receive a copy of these instructions. You can take notes, but you don't have to. Remember, you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions, I guess options fits too, of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job, no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the laws I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that defendant is innocent. This presumption continues throughout the trial and entitles defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove his innocence or to do anything at all. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts in this case, and you should decide this case from the evidence. At times during the trial, you excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only in the evidence I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and general knowledge and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There are no fixed set rules for judging whether you believe a witness, but it may help you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not important, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Count 1, carrying concealed weapon, pistol. Defendant is charged with the crime of carrying a pistol in a vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, a pistol was in a vehicle that defendant was in. Second, defendant knew the pistol was there. Third, defendant took part in carrying or keeping the pistol in the vehicle. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 19th, 2025 within Ingham County. Defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. An essential element of the crime of carrying a concealed weapon is that defendant must have knowingly carried the weapon. If you are not convinced beyond a reasonable doubt that defendant knew the weapon was in the automobile, then you must find defendant not guilty. The prosecution has introduced evidence of a statement it claims defendant made. Before you may consider such an out-of-court statement against defendant, you must first find that defendant actually made the statement as given to you. If you find that defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe defendant's testimony. You may consider whether defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that defendant had a reason to commit the alleged crime. He only has to show that defendant actually committed the crime and that he meant to do so. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. Possible penalty should not influence your decision. If you find defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. If you need to communicate with me while you're in the jury room, please have your foreperson write a note and give it to Brian. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal your voting to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions will be provided to you, and you may now share your notes. If you want to look at any or all of the exhibits that have been admitted, just ask for them, they will immediately be provided. We do have, if you want to relook at the video, we do have a clean computer that will provide to you so you can play it at your leisure. When you go to the jury room, you should discuss the case and think about all my instructions together as the law you are to follow. In the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike manner and that everyone has a fair chance to be heard. During your deliberations, you will not have your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case amongst yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror, and that's where, again, the polling of the jury may occur, I don't know. And you'll answer those two questions. Was the decision of the whole body, and was it your individual decision as well? It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. Although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, I'll answer them before you go to the jury room. Or if you have questions that arise during deliberations, submit them in writing again. If your handwriting is horrible, please print and provide that to Brian, and we will get the questions answered. You may return a verdict of guilty of the alleged crime or not guilty of the alleged crime. A verdict form has been prepared. Now, while each of you will have your own copy of the instructions, I only provide one copy of the verdict form, and that's because it's an official document. It will become an official document once you fill it out, and then it's filed downstairs with the clerk in this case. So you'll all have access to it. It is not a secret, but we only give you one verdict form, and the foreperson should maintain control of it, and you'll all have access, as I said. The verdict form reads as follows. Possible verdicts. You may return only one verdict. Mark only one verdict. Count one. There's a line, and then it says not guilty, and then under that there's a line, and it says guilty of carrying concealed weapon. There's a line for the date and for the foreperson's signature. So the foreperson has the responsibility of filling this out, and then when you all come back, I will ask if a foreperson has been chosen, and if the foreperson can please stand and then read the verdict in a nice loud voice. On behalf of the people, are you satisfied with the reading of this set of instructions?
People are satisfied, Your
On
Honor.
behalf of the defendant?
Yes, Your Honor, thank you.
Thank you. Please raise your right hand, state your name.
Brian Ring, Bryan, Ring, RING.
Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors in this trial from separating from each other? That you will not allow any communication to be made to them orally or otherwise? That you will not communicate with them orally or otherwise, except upon order of this court, or to ask them if they have agreed upon a verdict until they are discharged? And that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you. Now, I have to give a speech at 4 o'clock, so I'm only gonna let you work until about 3:35 or 3:40 at the latest. And if you do not, and there's no rush on verdict, not at all. So it's late in the day, you've been here all day, so if there's no verdict, then we will return Wednesday at 9 AM. Where is Wednesday, isn't it? Well, snow days with my kids, I lost track of what day we're even in, but anyways, Wednesday at 9 AM, you'll return and continue your deliberations. At this time, 2 of you will be discharged. As I said, you're discharged from being here, go about your life, just don't talk about this. And as soon as there is a verdict, Brian will call you, if you need to be called in, again, Brian will call you, so. Make sure before you leave that you have your electronics, anything else you brought with you, and that you leave your phone number with, Brian. As to the 2 that who are discharged.
I would like to thank and excuse juror number 1 and juror number 11.
All right.
We'll get, as soon as I
All
get
right.
you that.
All rise.
Anything we need to address on behalf of people?
No, Your Honor, thank
You
you.
have to finish.
No, Your Honor, thank you.
All right, so if there's questions, I would just stick around for half an hour and then, sorry about this, but I have to go. But for that snow day, we probably would have been done, and so I had agreed to do the speech, so I can't get out of it now. But anyways, we'll resume tomorrow at 9. As long as you're 20 minutes or so away, you don't, it's up to you whether or not you want to be in the building. Today, just stick around half an hour, so we can grab you quickly, and then if they want any of the exhibits, may I just give them?
They're over there on
All
the,
right, and do we have the clean computer?
I can go get that right now.
Okay, just to save time.
Yes.
And then,